Good morning, Chair Dingra and members of the committee. My name is Gabrielle Charlton, and I'm here today to speak in favor of Senate Bill 6227. I'm a senior deputy prosecuting attorney with King County, where I have worked for almost 2 decades. Since 2018, I have overseen our not guilty by reason of insanity caseload, or as we call them, NGRI cases for short. In addition to that, I work in our felony competency and forensic mental health unit. And prior to that, I spent much of my career in the domestic violence unit. For King County, the NGRI caseload is roughly 100 cases. While this is a small number, these cases are some of the most serious and most challenging cases we see. The majority of the NGRI caseload are Class A felonies, which include arson, assault in the first degree, and homicide. While the purpose of the NGRI statute is to provide treatment for those who were suffering from a behavioral health crisis at the time of their crime, for the victims of these crimes, that does not change the lasting trauma of these profound events. It does not change their fears. Currently, when a defendant is acquitted by reason of insanity, the court may include no contact with the victim or the victim's family as simply a condition within the NGRI commitment or conditional release. This means that does not go online to law enforcement, and if a victim were to call 911 for a violation, police would not see the order and have no basis to respond. That leaves a civil protection order as the only avenue to fully protect a victim. This puts a great onus on the victim, requiring them to file a petition, go to court, serve the defendant, and draw potentially unwelcome attention to themselves. Many victims are not willing or able to do this for a variety of reasons as they calculate their own safety. If this same case had ended in a conviction rather than NGRI, the victim would not have the onus of obtaining a protection order to keep themselves safe. The court would issue a no contact order under RCW 1099 that goes to law enforcement. This bill would provide that same protection here. All the more critically important as many of these NGRI defendants eventually reintegrate into our communities. It will ensure that victims in NGRI cases receive the same protections as other crime victims. Thank you.
Thank you so much for that, Gabby. Go ahead, David.
Good morning. My name is David Talley. I'm a victim advocate with the King County Prosecuting Attorney's Office. I work with victims and provide advocacy through the legal process surrounding competency and NGRI. Katie is one of the survivors I work with. I've been working with...
I'm sorry, could I have you move the mic closer to you?
Is that better? Oh, wow, that is better. Okay. Katie is one of the survivors I work with. I have been working with Katie for about 1.5 years, but she was shot back in 2006. If Katie's assailant had been convicted of assault in the first degree, the current law provides for a protection order issued at sentencing by the court with no additional burden put on her. However, her assailant pled not guilty by reason of insanity, so no such order, protection order has been afforded to her. Katie provided me a letter to read to you all today. Hello, my name is Katie, and I'm a domestic violence survivor. I'm writing you this letter today because I feel my words might be able to help other survivors. Back in 2006, I was living with my ex-boyfriend, Brian. March 27th, 2006 was the day my whole life changed. I saw Brian out of the corner of my eye, so I looked up, and I saw him standing there with a gun pointing at me. I covered my head and said, "No, baby, please don't." Then a loud bang. Everything went black and my ears were ringing. I remember thinking, just breathe, just breathe. I realized I was shot in the face because I had covered my head. The bullet passed through my forearm, entered above my left eye, broke my nose, exited my face just 3 centimeters below my right eye, and was stuck in my right bicep. It wasn't until later I learned that Brian had shot himself in the head and then threw himself off the balcony. While going through the judicial process, I was told I could get a civil protection order, but I would have to give him my information. I decided not to file a protection order because I felt it would only put me in danger. Years went by with Brian committed to Western State Hospital. In 2016, I received a phone call that Brian was given permission to leave Western to visit his family in Seattle. While he was visiting his family, he stole his sister's car and was on the run. Brian tried to contact me on social media and then tried to find me at my job and my home. When I contacted the police, I asked if there was any way to get a protection order without giving out so much personal information. I was told it wasn't possible and it was fair to the person I needed protection from. He needed to know where I was so he could avoid me. Plus, he was on the run. How was I going to serve him? After a few days on the run, Brian turned himself in. He was halfway across the country. Recently, Brian made a request that would allow him to visit his family once again. I now live in fear of the day that Brian is released from Western State. I worry for the family I now have and the members he knows personally. I would love to be strong enough to be there with you all today, but unfortunately having to relive this nightmare in front of strangers is too hard for me. I would like for all of you to remember that I'm a real person, that I am my mother and my father's firstborn daughter, my grandparents' firstborn grandchild, my sister's best friend, an active member in my community, a volunteer for a suicide prevention group, a Mariners fan, a survivor, a protector, a voice for the people who did not survive their attacker. Getting a civil protection order is just not a smart move for me or others like me. Having a protection order issued during the criminal proceedings might have stopped Brian from attempting to contact me in the past. It would have removed the need for a civil protection order and the barriers that come with it. It would have provided me a layer of protection should he have found me. This has been an extremely hard letter to write, and I appreciate you taking the time to listen to my story. There are many other survivors in Katie's shoes. Katie and other survivors should be afforded the same protection as other survivors. Thank you for your time and consideration.
Thank you so much, Gabby and David. Any questions for this panel? Seeing none, we're now going to hear from Carrie Reardon, who's going to be joining